Justice Breyer, welcome to Meet the Press.
Oh, thank you very much.
Thank you so much for being here. It's an honor. I want to ask you about your latest book, Reading the Constitution, Why I Chose Pragmatism, Not Textualism. You define pragmatism as a purpose-oriented approach to the law and textualism as a text-based or linguistic approach to the law. Do you see the choice between the two as the most important issue facing the court today?
At the moment, but I'd put it this way. Every judge, everyone, reads the text of a statute or the Constitution if that's in the case. You know, if that text says fish, that does not mean a carrot. Okay? Got it? And really the question is, there are those who say we should look only at the text. Now, that's where I disagree. Because I think the way I look at it, it depends on the case, what you look at, but a lot of the time, there are words on a piece of paper, and there are words in that Constitution. Someone wrote them, and when you're looking at a statute, you want to know what that person had in mind. He had an objective. He had a purpose, and it often, not always, but often will help the judge if he goes on to try to figure out what is that purpose.
So do you see the tension between textualism and pragmatism as the most important issue that the court is dealing with?
At the moment,
yes.
I think probably it is. And they don't necessarily, you know, how a judge approaches a particular problem is something that people have talked about for a long time. And what I think of when I look at the purposes or the consequences of interpreting it this way or interpreting it that way, when I think of those consequences or the values that underlie them, I think that's a traditional method. It's a traditional method. But more recently, people have tried to stay away from looking at what the purpose was, and I think that's a mistake.
Well, critics, of course, of pragmatism have said that it opens the door for judges to legislate from the bench. You are familiar with this, to engage in judicial activism. How do you respond to that criticism?
I say if a judge wants to be dishonest, he can be dishonest. What you're trying to figure out, if you're interested in the purpose, is what was the purpose? If you're trying to figure out how knowing about the purpose leads you to a certain interpretation, then you do that. You don't do something else. And if you want to apply a textualism in a way that you're just choosing any old thing that you think is good or so forth, you could do that too. Hey, there's no difference there that I see. But if you are in this job, do the job properly.
You write in the book, quote, "Major changes take time, and there are many years left for the newly appointed justices to decide whether they want to build the law using only textualism and originalism or instead taking advantage of all the methods you describe in the book." Are you worried that the conservative members of the court are moving too quickly to change the law, Justice Breyer?
What I'm thinking of there is for every judge, and David Souter said this, and Justice Douglas said this, they said it takes some time. You're first appointed. You thought you could do this job. And then you're there. And then you begin to think, my goodness, can I really? I certainly hope so. And you may not appear to be a little nervous, but you are. And it takes, I think Douglas, or I can't remember whether it was David, but 3 years, 4 years, 5 years, before you become comfortable. And becoming comfortable means, well, I can do my best. And that's about it. And every one of the people, I think there, and the people probably in the past who have been appointed, think that's basically what I'm supposed to do. Spend the time, make the effort. You see, it's a doctor. A doctor doesn't say about a patient, oh, I only have one of these, I don't have to worry about it. He says, this patient needs me. And in a job like this, you think, my goodness, you can't let up. And that, by the way, is the great privilege as you get older, that you are in a job that requires you to give your best all the time. Now, it takes time before you're comfortable with that, and it will take time. And pretty soon, I think, I heard President Clinton say this, the applause dies away faster than you think, and you're left with the job. So you better like it.
Profound words. To go back to your quote and everything that you're saying here, though, do you have concerns that the conservative justices are moving too quickly to try to shape the law? Are you trying to sound an alarm, as the New York Times put it?
You have to get the right word to describe it. What I'm trying to do in the book is I'm saying there is what I call a traditional approach towards interpretation, particularly of the Constitution, particularly of statutes, and that's been moving in the direction of just looking at text. Now, they don't always just look at text, but it's been moving in that direction. So if you ask me, would I prefer it move more slowly or not at all? But we look at all the things that are traditionally looked at. The answer is yes, of course.
So
of course.
Just to be clear, you think the court is moving too quickly toward textualism?
Too quickly? That suggests that I think slow movement towards textualism would be okay. No, I don't. I think it's a bad idea as a method for interpreting the Constitution of the United States. I think it's a bad idea. Why? Because if you limit yourself to that, you risk overlooking the values that underlie that document. I mean, this is a document, and most people understand this, even if they haven't read it, and it's a good idea to read it. It isn't that long, you know. I mean, but what? A democratic form of government? A form that respects human liberty? A form that insists upon a degree of equality, a rule of law, separation of powers so no group of people gets too powerful. I mean, there are values that underlie this document and the people who wrote it.
So just to be clear, you carry a copy of the Constitution around in all of your suit jackets, just in case you need to reference
all of them? I don't know. I have some pretty old suits there.
In many of them.
In some, yes. Yeah, right.
You told the New York Times of the court today, something important is going on. What did you mean by that?
No, I meant really what I've been writing here, that I think the most important thing or characteristic to focus on is a change in the way that people are interpreting, in general, this document and the statutes towards what did people originally, when this was written, what did they take these words to mean in general? See, it's very attractive. You say that textualism, all you have to do is read this. Fabulous. You've got the answer. Just read it. And it's simple. And it'll stop the judges from doing what they want. They'll be bound by the text. You say, sounds good. Sounds good. But it doesn't work very well, in my opinion. And that's why I've spent a year and a half trying to explain why.
And your argument is that an originalist, a textualist approach ignores the changes, the realities of society that have occurred since the Constitution.
That's one of the things. If you go to look at the Constitution, remember this. This is an important point. Go back to 1788, 89, 87. Go back even to just after the Civil War when we have the 13th, 14th, 15th Amendment. You remember? You don't remember. I'm not even that old. I mean, but there were about half the population in this country that really weren't represented in the political process, right?
Yes.
And but they're now part of the political process, as they should be. And so you want to just do history? You want to just go back to what people were thinking at that time? I'm not sure of just what they were thinking at that time. But I do suspect that the fact that half the people in this country were not involved in the political process, you know, they were supposed to stay home. And there were some that were enslaved. And we understand that. So that's one of the problems with just looking back into history. Another problem? Maybe I shouldn't admit this. I'm a judge. I'm not a historian. I'm not even a very good historian. I'd like to think I could be, maybe. But regardless, judges are not historians. So beware of law office history. And if you start to say, oh, well, looking back at that history, we'll keep them under control. It will? It will? I mean, I could give you a few examples.
You say beware of law office history. Are you concerned about the direction that the court is taking, this turn towards textualism?
Oh, I've written this book saying I think this is a bad approach.
So that's a yes.
Well, it is what I think is the correct approach here, which is a more traditional approach. You go back to John Marshall. What did he say? John Marshall studied about statutes. He said, we'll use whatever tools we can get our hands on that is going to help us interpret this statute. Constitution, it should last. It should last for probably, he thought, centuries. And was that important for him to say it is a constitution we are expounding? It's written down here in this law school somewhere in one of these rooms across the wall. And what does it mean? It means there are values here that we want to last. And do we think the values will change over the future? Perhaps not. But will the circumstances in which we apply those values change? Yes, of course. And we would debate this. Nino Scalia and I would debate it. I would say, Nino, George Washington didn't know about the internet. And you know what he said?
What would he say?
He'd say, I knew that. and then he would say, if you want to know both sides of this argument, he would say, well, our discussion, and we were good friends, and the audience, which was a bunch of students and high school students and college students and law school students, they're all there and they're listening and they see that we're good friends. So he would say, it's like the two campers. You know the two campers? Mm. Two campers, one of them is putting on his running shoes, and the other says, why are you putting on your running shoes? He says, because there's a bear in the camp. He says, you can't outrun a bear. And the first one says, that's right, but I can outrun you. You see? Yeah. So he's saying, I'm not saying I have the perfect solution. I just have one better than yours. Yours is so complicated that only you could do it. And then I say to him, I'll tell you, if we adopt yours, you're going to have a constitution no one wants. That conversation goes on, and the answer may not be reached for a long time, but I hold the first position there.
Let me ask you about what we're seeing with the court today. The presidential election is more than 7 months away. Already the court has decided one major case impacting the election, and at least one more is on the docket. Are you comfortable with the role the Supreme Court is playing in the 2024 election?
That isn't the kind of choice a court really faces. I mean, what's rather interesting, it is a much more technical job, even on the Supreme Court, than people think. You see, the cases that we'll take depend upon the cases that we're asked to take. Every year, we get about maybe 6,000 to 7,000 requests to take cases out of the federal system, present a federal question, or out of the state system that present a federal question, a question of law passed by Congress, or this document. Now, that's about 100 a week or so, is it? 52, about 120 a week. And we'll only grant one or two. And we have criteria. The criteria are usually, almost exclusively, but not entirely, did the lower courts come to different conclusions on the same question of federal law? If the answer to that question is yes, we'll probably take the case. If the answer is no, we probably won't, you see. Now, why not? Because they're good judges. So if they've all reached the same conclusion, why do we want to take it? But there are other criteria, too. Sometimes a lower court will hold a law of Congress unconstitutional. We'll take it. And sometimes, and this is what you're thinking of, probably mostly, sometimes, but not often, we'll take a case, say, like Guantanamo, where they may not be this split, but it just seems of great importance to the nation. Now, that's a hard thing to judge. It doesn't arise very often. And so to know whether this is one of those cases or not, or to know whether there is a split, or to know whether there's been a holding of unconstitutionality. I shouldn't say this to you. but I will.
Please do.
Well, you've got to do more than just read the newspapers. you have to do more than just listen to the press. You have to actually read the briefs, understand the lower court opinions, and then you discuss it in the conference, and you have your law clerks write memos on it, and it is a major process that you go through seriously before you're going to vote to grant a case.
Are there lessons right now that the court can take from Bush v. Gore, which you were
No, the lesson on Bush v. Gore. Bush v. Gore. I dissented in Bush v. Gore on the main thing, but what I heard about that, I think was best said by Senator Reid in the Supreme Court building. He was there for dinner or giving a talk or something. And he said the most remarkable thing about that case, rarely remarked, even though important, affects you and you might disagree with it. Yeah, a lot of disagreement. Yeah, at least half the country, and a lot. And it might be wrong. I thought it was wrong, and I bet he thought it was wrong. Now, despite that, there were no riots. There were no rocks thrown in the street. There were no guns. Okay, that, he says, is remarkable. And I say this to the students at Stanford. And I said because I'm a little bit of a realist, I said, I know, when I say this to you, at least a third of you are thinking, too bad there weren't a few riots. Too bad there weren't a few rocks thrown. And I said, but before you reach that as your final conclusion, please, turn on the television set. Yeah, and look and learn about what happens in countries that solve their major differences that way. And you know who I told that to? That very story that I've just told you. I've told it a lot because it means something to me. But the president of the Supreme Court of Ghana, a woman who wanted to bring more civil rights into the law of Ghana, and she asked me, why do people do what you say? And I had to think about that and tell her a lot of stories of a lot of cases, and how it's taken this country dozens, hundreds perhaps, of years before people begin to see that maybe they should follow cases, even though they think they're wrong, important, and don't like them one little bit. And when you have that, you have a rule of law. And that is what I told her she's working for. And we're still working for it, because Abraham Lincoln and George Washington both said this nation is an experiment. And that's what I want those students at Stanford to know. I want them to know you're in the midst of an experiment. And that continues, and you better help. And they ask me what to do. I say, my friends, you are the ones that have to keep this experiment going. And yeah, sorry.
No, it's one I'm going to ask you actually about your thoughts on where we are in that experiment in just a moment. But I want to ask you about the Supreme Court's unanimous decision earlier this month, holding that states cannot rely on the 14th Amendment's insurrection clause to disqualify Donald Trump from their ballots. What did you think of that decision?
Oh, did I think about it? Yeah.
What did you think of it?
Oh, well, I'm not going to ask. Why? Because, I think one of the really unfortunate things I could do is retire from the court and then sit here and criticize particular cases or not criticize them. I'm not in the position, unlike you, you can do it, but I think publicly praising or blaming particular decisions that the court now makes. You want to go back? I can tell you, I can criticize some. Dred Scott was a terrible decision, and so forth. And Brown versus Board of Education was a very good one. We can go back in time.
There's a lot of agreement on both of those.
Right. But I don't think I can really go into discussing the merits of recent decisions.
Without asking you to weigh in on or judge the decision itself, can you tell me, did you think that the decision and that the justices took an originalist approach, or did they take a pragmatic approach? to looking at the 14th Amendment?
Not sure. I haven't read the decision. I'm not being coy in this one. I haven't. That's a good question. It really is. And I haven't read the decision with that in mind. Seems more pragmatic, but I'm not sure. I'm really not sure. I'd have to go back and read it. I mean, they spend a lot of effort in there saying, well, what's going to happen if states can do this? And one state will do one thing, one state will do another thing. You know, they go into it in some depth. So I would say, you have read this book, for which I thank you. and you're in a position where you can answer that question. Go back and read their decision and see what you think.
Well, that's why I asked, because originalists argue that a strict adherence to the original text suggests Trump should have been disqualified. Is that the wrong conclusion, or are they right about that?
No, Your Honor, I'm not going. I can't. I just can't. I'm sorry.
That's okay.
But you know, I'd like to talk to my class about that on the ground they don't have their iPad with them.
Well, I'm glad I've given you a new topic to discuss with your law class. Let me ask you about the immunity case, if I could. In April, the court is going to hear arguments about Donald Trump's claim to be immune from criminal prosecution for his efforts to overturn the 2020 election. Why do you think the court took the case, and was it necessary for the court to take the case?
No, that's another kind. See, if I'm sitting around the table, I've read the briefs, and that isn't being coy. It's true. My goodness, you can make mistakes just by saying what your initial opinion is. And my goodness, how often it really occurs. I'm not just trying to get out of the question, because I can get out of the question by just saying I'm not going to answer the question. But the point is, there's so many times when you think, look, this is how decision making, and I bet it's true for you, and I bet it's true for the people who work with you, and I bet it's true for business people and others. Okay, we get briefs. I read the question in the blue brief. Guess what? I read it, I know the answer. Then I read the blue brief. Yes, I certainly was right. Then I read the red brief. Not so fast. Then the yellow brief, then the green briefs, and then we hear oral argument, and I ask a few questions, and then we go and have a conference. And I always have learned there, being open-minded is not having a blank mind. It means being willing to change your views when faced with evidence and argument that shows you the contrary was correct. And that's why it's genuinely important to understand as best you can the details that are relevant to an important decision. And I think that's true of everyone who makes those decisions. But it's certainly true of a justice of the court.
Let me try it this way. Were you surprised that they took up the case, or were you expecting them to?
I didn't even, I may have thought about that, but that's too close, too close.
Let me ask you about some of the arguments that we have heard. Donald Trump's lawyers argued before the D.C. Circuit Court that he would be immune from prosecution even if he had directed SEAL Team 6 to assassinate a political opponent. What do you make of that argument?
Same problem.
Do you think that a president...
Yeah, I just can't do it. I know
it
would be much more, I understand that, but I just can't. I can't go into the arguments that are particularly...
Let me ask you this. Do you think anyone should have total immunity?
Do I think anyone? Well, anyone, total immunity, what does that mean? Judges, have immunity, but it's some immunity.
Should presidents have total immunity?
Oh, well, that's the main question I can't answer.
Do you have thoughts about it?
Do I have thoughts? Yeah, but as I told you, to get a sensible if you could get the entire audience, if there is an audience here, if they could forget the fact that I'm a judge and wipe that out of their minds and just treat me as, then maybe I could consider answering the question, but they won't. And as long as I am a judge, I really can't answer it without doing the kinds of work that I've described. I just can't.
I understand.
And I can't. And I wouldn't probably, even if I weren't a judge. It's not right for me to answer.
Let me ask it this way. You are a judge who knows what it is like to take up a critical case in the middle of a presidential election. Can you
that
talk
was Bush
about,
v. Gore, you mean?
Yes, Bush v. Gore.
I do remember
Can
that.
you talk
and I
about...
wrote, in my opinion, I wrote they shouldn't have taken it up. That's what I thought about
Yes.
Bush v. Gore. I said they shouldn't have taken up the opinion, and now having taken it up, I think they should decide it the other way. That was my view, all right? But it was a view reached after a considerable amount of work.
Can you describe the weight that you felt, that one feels as a justice, when you are presented with a case in the middle of a presidential election?
It's not just an election. I mean, the court, imagine you were on the court that decided Brown versus Board of Education. Imagine that you were on the court that had to decide, well, for example, whether President Nixon was immune from didn't have to turn the tapes over to Archie Cox. Imagine that. And I can give you a lot of cases which produce imagine to be realistic, and I can be realistic and personal here. We had a case called Parents Involved, which involved affirmative action in high schools. And I was sort of in the middle. I felt that they were really wrong on that one, and I dissented. All right, that was a hard case, and it was particularly hard because I wanted to persuade. I wanted to persuade after I reached how I felt about it. I wanted to persuade my colleagues, and there are many cases there that, of course, you feel strongly. You think about it. You work hard. It is not a job where you are emotionally, detached. You do become attached to the views that you end up holding, and that's all part of the job. You don't get angry at your colleagues. I was a law clerk for Arthur Goldberg. We lost a few cases. When I was a law clerk, he'd come in and say, we lost cases here. We lost this case. So, what do we do next? We don't sit down and weep. We look forward to the next case and the case after that. And so you keep working and you keep going and you keep explaining. And getting angry, if I get angry at one of my colleagues, I can tell Joanna, my wife, but the mood in that room, the conference room, the mood in the court, I've never heard in that conference room a voice raised in anger. It doesn't happen. It's professional, it's serious, and that doesn't mean people don't take it seriously. Believe me, they do. But they try as best they can to get along well with their colleagues, and they do. I've never heard in that conference room one judge say anything snide or mean or even as a joke about a fellow colleague. The 9 people get on. As people, you recognize that they can be friends, they're certainly good acquaintances, you certainly can enjoy them, and you still can disagree completely on the merits of a significant issue.
And I know you like hypothetical situations. Given how divided the country is right now, how do you think Bush v. Gore would impact the country in this very moment? Would the reaction be exactly as it was then?
Of course I don't know. But when we're divided and so forth, if I can deviate a little bit from the question, what comes to... I worked for Senator Kennedy, Ted Kennedy, for several years. And what he would say he'd say 2 things that really stuck. And the first one was, look, when others disagree with you and we can't get our bill through or we can't accomplish this objective, hey, talk to them. Talk to them. Wait. When you talk to them, listen. Listen to what they say. Listen and talk. And if you go for a while and you go long enough, you will discover they actually say something that you actually agree with. And when you agree with it, you say, that's a good point. Let's see if we can work with that. And then if you accomplish 30% of what you wanted, great. Don't say you want 100% that you're not getting. Because you may be a hero to your followers with 100%, but you've gotten nothing. So be helpful, be satisfied with that 30%. That will help you. And when the press is there you are. And you, in your press capacity, say to Senator Kennedy, great, you got that bill through. He will say, don't thank me. Thank Orrin Hatch. He's the one, when we were talking, that came up with the idea that allowed us to work together and to accomplish a result. Credit is a weapon. Credit is, he'd say, if you succeed, there'll be plenty of credit to go around. And if you fail, who wants it? I mean, you see the kind of thing that I feel that those sorts of things that I learned from him, and I loved working there. It was, he was fun, and it was also serious. And those kinds of things, I think, work. And what I tell the high school students, the college students, hey, my friends, I just said it's up to you. But I can tell you one thing I really hope. I hope you will be out there participating. I hope you will participate. I hope you will talk to people who disagree with you. And by the way, talking to them doesn't mean shouting at them. It means listening. See where they're coming from. See if you can, in fact, work with that. See if you can get somewhere, even if it's only 30%. But do it.
Do you worry that too many people have lost the ability to listen in this country?
Yes.
And where does that leave us?
Bad.
Mm-hmm. What does that potentially mean for the state of this country's democracy?
Okay, look, there are two sides to many things. One, you say the United States of America. Hey, this is in part the United States of America. So the United States of America, we used to think, and I still think, that maybe we're not listening as much as we should, but we're also pretty good at one thing that I learned in the 5th grade. Mrs. Squataguatza. My 5th grade teacher would take the class divided into groups of 4, and say, you have a project here, and you will, in fact, get 1 grade. When you get 1 grade for 4 people, those 4 people learn to work together. And I thought Americans were pretty good at working together. And I noticed, even in Cambridge, Massachusetts, where we are at this moment, during COVID, there would be groups of people who would come around. Why? To see if older people are okay, to see if they have the food they need, to see if they can get the shots they need. And that didn't just happen in Cambridge. It happened in San Diego, it happens in St. Louis, it happens all over the place. And we still do have the ability. We still do have the ability to get together in groups on 1,000 different topics and get something done. And it's not difficult to find that. And that's why I like that. I'm not taking a political point of view, but when one of our candidates said, yes, we can, I think, yes, we can. Yes, we can. And that's the way I was brought up. And that's the way that I learned how to live in San Francisco. And that's the way that, that I think this country went across, and you could go on indefinitely. But we have that ability, and there's no reason we can't exercise it.
I know that you're not going to weigh in on the current cases before the court, but big picture, Justice Breyer, do you think that the people of this country deserve to know a verdict in the election subversion case before November, as a legal matter?
You're still going. I mean, you have a lot of good questions, but they're all aiming at the same place.
Big picture.
Yeah,
big picture.
All right, big picture.
Do the people of this country deserve to know?
Big picture. The big picture
Before
is I'm
November?
not going near a case that has to do with it so much. That is an even bigger picture.
Let me just ask you
What?
this. Can you tell me what you thought on January 6th as those events were unfolding?
No. On January 6th, the biggest picture is, to me, that I tell myself, don't go near these issues. Was it a
tough
were
day for you?
many advantages and privileges when I think that I was a member of the Supreme Court of the United States. Mm-hmm. And there are a few disadvantages. And one of those disadvantages is don't sound off on things that are relevant, might become cases, etc. particularly whether you're on the court or not. You were on the court. And Lee Campbell, who was my colleague on the First Circuit, he told me this. You know what he said?
What did he say?
He says, judges are people who have a considerable amount of power in a narrowly defined area, maybe broader on the Supreme Court, but still pretty narrow compared. And when they start talking about other things than those things right in front of them, the lawyers will say, how intelligent, how interesting. And they'll go out of the room and they'll say to each other, there he goes again. You say, don't do it.
Okay. Let's turn to a case that was decided, Dobbs.
I did say a few things about Dobbs in here, but I have to be careful there, but yes. I did say a few
Okay, well, let's talk about Dobbs. It will be 2 years since Dobbs, as you know, ended the constitutional right to get an abortion. You dissented. What do you think the impact of Dobbs has been?
Well, has been, so what I put in this book, and I want to stick to that because Dobbs is a recent case. I said, I haven't said anything in this book that I didn't write when I was on the court in a dissent.
Yeah.
And so in that dissent, the three of us wrote together, Sotomayor, Kagan, and myself. And one of the things we said is what we fear, they think this will be simpler, the majority, because it will leave it all up to the states. We don't think it will be simpler. We think that there will be a lot of more cases coming up. I mean, what's going to happen when a woman's life is at stake and she needs the abortion? Do you think if a state forbids that won't come to the courts? Well, we thought it probably would. And we thought there would be a lot of issues coming to the courts coming out of the decision to overrule Roe versus Wade. That's what we said in the opinion.
Well, and you also said the majority's refusal even to consider the life-altering consequences of reversing Roe and Casey is a stunning indictment of its decision. Those are very strong words.
We felt strongly on that case, yes.
Well, and I guess the question is what you anticipated, has it come to pass?
No, that's what I can't. I want to stay away from, it's not that I don't have answers for these things in my mind, but I want to stay away publicly from, I want to stick as closely on a recent case as possible to what I said in this book. And I did my best to stick to as close as possible to what is already public. In other words, we have totally opposite interests there because my interest is not to make news.
Well, I'm trying hard, Justice Breyer.
I know.
Let me ask you, in Texas, there were estimated to be more than 26,000 rape-related pregnancies in the first 16 months after the state's near total abortion ban was in effect. And part of the dissent does talk about the concerns about a patchwork of laws. Was that part of your concern when you dissented to Roe being overturned?
I thought Roe should not be overturned. I thought Casey should not be overturned. We spent plenty of pages explaining why, and I spent some more pages in this book. This is the difficulty with this kind of issue. I thought, in women's it was the abortion case that I wrote before Dobbs, and it affirmed Roe, and it affirmed.
You mean Casey, or
no? It affirmed Casey. It affirmed Roe. It was, but I thought, one of the cases I wrote on abortion. I thought, well, I'm going to help here. Here's what I'll say in the first line. I said something like this. I said that there are millions of people in the United States that think for a woman to have an abortion is to murder an innocent person. There are millions of people in the United States who think that to forbid a woman from having an abortion is going to lead to thousands or more deaths of innocent people. We need not decide who is right. We do have to decide what kind of law is there in a country where both of those beliefs are held. Now, I thought that was probably right. And I thought that the better rule in such a country, Roe and Casey. Okay? Now, you know who I convinced with my opening line, which I thought was so good? Nobody. Absolutely nobody. All right? But we still have to have a law. And so there we are, 50 years, 60 years, 70 years, however, and it's worked fairly well. And you can read in the dissent, you can read here why I had thought, and the others, dissenters also thought, and probably I think many, maybe millions, maybe tens of thousands of people in this country also think that the better rule is the rule of Roe, is the rule of Casey versus Polino. All right? Now, there we are.
Can you see a world, a possibility in which Dobbs is overturned one day in another 50 years, say?
Don't know.
It's possible?
Oh, it's possible. But who knows?
How disruptive was the leak to the court and to the relationships that you describe?
It was unfortunate.
Were you angry?
You try to avoid getting angry where that affect. You try in a job, you try to remain as calm, reasonable, and serious as possible. I think it was unfortunate, that leak. How
much discussion was there about a potential compromise around 15 weeks?
Well, you know as much about that as I do. You saw what Chief Justice Roberts wrote. And when you see what is written, the normal situation is before something is written in the conference, people in some form or other will discuss what they're thinking of writing. Not always, and not identical, but there's usually some discussion.
Did you think that a compromise was possible before the leak? Around 15 weeks?
I usually hope for compromise.
So you were hopeful there could be a compromise?
Well, you want to put words in my mouth. I'm careful what I say on this, because I say our interests are different. I don't want to make news. I've written what I thought. If you think there's news in here or in the dissent, go right ahead. Well, but I don't want to say something in addition.
Yeah. Just to be clear, though, did you think a compromise was possible?
I always think it's possible. I always think it's possible, usually up until the last minute.
Were you surprised that the internal investigation didn't determine who was actually behind the leak?
Saw that.
Did you...
Yeah, you better ask. If you want to ask that question, but somebody who knows something about it, ask the people who do internal investigations like that. They're the people to ask, and and that they occur all over the government.
But did you feel betrayed by the leak?
That's a stronger way of putting what you've already asked. I was disappointed. I was sorry about the leak.
Mm-hmm. And do you have a theory of the case? Do you think that the leaker was someone who wanted to sound the alarm about Roe being overturned, or wanted the draft opinion to be locked in place? Do you have your own theory?
Do I have my theories about it? Yes.
But you're not going to share them with me.
Correct.
Can you talk about it in that broader context, though? Do you have a sense of what the motive of the leaker was?
That's part of the theory.
Can you share that?
No, I can't really.
But given you've said you were disappointed, did you spend time thinking about? Clearly, you have a theory, something that you spent time thinking about.
You have a theory. People have theories. I mean, I don't mean to be coy but I really don't want to get into something. As I say, our interests are opposite there. I'm happy talking about this book. I'm happy talking about what I've written. I'm happy talking about what I've written in opinions. But I don't really want to go beyond that with matters that are currently controversial.
Understood. And fair to say the fact that you're disappointed, you were not behind this in any way.
I'm not even going to say that. I mean, of course, I'd be amazed if it was a judge.
Okay.
There. But I don't know. We never know.
Yeah. And I think what you described the relationships on the court
as good.
And, You talk about the fact that you deal with these very thorny issues together.
Yes.
Is the leak something that disrupted the balance?
No one liked the leak, as far as I know. Everybody was disappointed, but we do get on we get on pretty well. I mean, you know, Nino and Ruth used to go to the opera, and what was really amazing about their going to the opera and being good friends, they invited Tony Kennedy, or they saw that Tony Kennedy and I were once invited to go to the opera too, and we sat on the stage. And I think it was Fledermaus or something like that. And we were told, don't open your mouth, which of course does make sense. But I enjoyed that. And we used to go with Sandra. I said, before I joined the court, I said, have you ever joined the court? Lord Cutler told me, follow Sandra O'Connor. So I said, well, you could do worse than follow. That was something like that, he said. So I said, well, I followed her. I followed her to Paris. I followed her to Luxembourg. And we got on very well, and David Souter and the others. And people get on well, you know, and they make an effort. Yeah. And I already said that, I think.
You address the issue of guns in this book
I do.
as well. And you think that the decision on guns went too far. Why do you think? What was your chief
Well, there I think it shows a couple of other things that are problems with textualism or originalism. I mean, you have to be a historian. Well, I'm not. And I looked up some of the guns in Wikipedia. Guns? There weren't guns in the 12th or 13th or 14th century. They used things like skin ladders or something, or halberds, or what was the... there was something called Asian fire, where you threw Asian fire over the wall, and the people on the other side of the walled city might be burned, or they might get a disease, or something bad would happen to them. And I said, are those, because it said in the article I was reading that was the origin of artillery, or something like that. So I said, are we supposed to look to that? Look back to that? You can't do that. You can't do it, you know. And that was one problem. And the other problem is, I remember this figure, 400 million guns in the United States. 400 million. We're first in the world. Yemen is second. Okay? So I said, are we not supposed to take that into account? Are we not supposed to take into account the number of policemen, or the number of children, or the number of spouses, or the number of innocent people, or the number of who are harmed, injured, possibly killed every year in the United States with guns? Is your theory telling us that we shouldn't take account of that? Because, of course, I think we should. And so the reason that I go into it in some length here is because I want to show, not tell. You know, there are plenty of people in this law school and other law schools who know a lot about the theory of textualism and the theory of originalism and looking at purposes and looking at values, looking at consequences. They know the theories of it very well, better than I. But I say I have had some experience with this over 40 years. And so what I want the reader of this book to see is, what does that experience tell me? What does it tell me? And in the gun case, it tells me that we should look to the consequences, that we should look to the practical facts of what is happening, and that should play a role in interpreting the Second Amendment. And that's even assuming, you know, I didn't think the history was right on Heller, which was the original case. The Second Amendment says a well-regulated militia being necessary for the security of a free state, something like that. The right of the people to keep and bear arms shall not be infringed. Okay? Well, I said that has to do with the militia. And Madison put it in there because there were people who thought that we shouldn't interpret, we shouldn't ratify the Constitution because Congress will call up our militia and disband it in our state. And Madison said, don't worry, I'll write a Second Amendment and Congress won't be able to call up the militia. I said, that's what this is about. And there are many historians who agreed with us. And the right to bear arms in a later case involving guns, a group of historians wrote in, or linguists or something, and they said, we've looked up 120,000 references to the words bear arms in between 1760 and 1780 or something, and almost all of them had to do with militias. You see, we're not the historians. We're not the historians, but we do have a sense of, and we're told in briefs, the practical facts, the practical consequences of what will happen if you interpret this way or you interpret that way. That's what I want people to see. That's what I want them to understand. This isn't a theory. This is an effort by 9 people in that case to go and look at what will happen if the Second Amendment is interpreted this way as opposed to that way, because it's relevant to the values that underlie the words in the Constitution, in this document.
I want to ask you some big picture questions about the court.
You understand I'm a little suspicious of those particular things.
No, don't be suspicious. I think you're going to like a few of them.
All right, good.
Dobbs happened in part, obviously, because Amy Coney Barrett replaced Ruth Bader Ginsburg, the late Ruth Bader Ginsburg, on the court, who passed away while she was still on the bench. Do you think there should be age limits on the Supreme Court?
I've said, and I think it's true, I don't think that's harmful. I mean, if you had long terms, for example, they'd have to be long. Why long? Because I don't think you want someone who's appointed to the Supreme Court to be thinking about his next job. And so a 20-year term, I don't know, 18 long term, fine. I don't think that would be harmful. I think it would have helped, in my case, it would have helped me it would have avoided for me going through difficult decisions. When do you retire? What's the right time? And so that would be okay.
How difficult was it for you to decide to retire?
It's difficult.
Do you miss being on the Supreme Court?
Of course. But yes, human life is tough. And moreover, you get older. And 85, which I am now, 83. I mean, you see, you've been there for quite a while. And other people also should have a chance at these jobs. And at some point, you're just not going to be able to do it. And I think I could do it, but nonetheless, there comes a time you have to figure out what's the right time. There are lots of considerations.
Was the ideological balance on the court part of your consideration to retire when you did?
There were a lot of things there, and probably part.
Mm-hmm. Mm-hmm. Let me ask you, I have to ask you because it's in the news,
yes.
So forgive me in advance.
All right,
One of the issues before the court is the Texas law that allows state officials to arrest and detain people that they suspect of entering the country illegally. Immigration enforcement is generally a function of the federal government. Do you think the Texas law is constitutional?
That's one of the things I have to stay away from.
Won't weigh in on it. Okay. Let me ask you about the public legitimacy of the court, if I could. Public sentiment toward the court has fallen, as you know, in recent years. Why do you think that is? And do you think that the onus is on the court to restore the public's trust?
The most, I think, applicable thought about that, you see, is there'll be ups and downs in public opinion, okay? There'll be right and wrong decisions that courts make, yes. The question really is, to what extent does that political reaction affect the court? And the best statement was Paul Freund's, who taught at this law school. He was a great professor and really knew a lot about the court. And he said the relation of politics to the court, roughly, I won't get the words exactly right, but roughly is this. He said that no judge is affected or should be affected by the temperature of the day. But every judge will and probably should be affected by the climate of the era.
And do you take those words to heart when
Yes.
you think about
No, I think about it. I mean, think of the New Deal Court and changing Lochner and moving away from the laws that said Congress cannot pass a minimum wage or maximum hours. Think of the changes. We've had changes in the court, in the climate of the era. The New Deal in the 30s was quite different than the earlier period. The earlier period, 1900, earlier, this country had experienced growth and prosperity, changes upward like no other. And nobody believed by 1930 that this was all due to laissez-faire, because they saw 24% unemployment. They saw terrible situations. Change. There had been change. And the attitude of the court changed too, as it changed again with Brown and other cases. So I can't go beyond what Paul Freund said, because he put it succinctly, he put it correctly.
What do you think the answer is? Not just for the court, but for public institutions writ large. It's one of the, as you talk about the state of democracy, the public is losing trust in public institutions, from the court to the media.
You probably weren't born at the time of Vietnam. I would suggest that if you have never seen it, watch Bobby Kennedy's speech in Indianapolis. Indianapolis, he was out in a poor neighborhood, mostly African American, on the day that Martin Luther King was assassinated. And the governor told him not to go, too dangerous. And he said, I'm going. Watch that speech. I mean, he talks about Aeschylus and it's a fabulous speech. But you have to remember this. One, only a few years earlier, his brother was killed. Only a few weeks after that, he will be assassinated. On that very day, Martin Luther King was killed. I think 20 students at Kent State were killed. I think that Watts was afire. I think that people were suggesting burning down Washington. I think that Vietnam had really divided the country. That's an era when I was a student and just a few years after. We've lived through some pretty tough stuff, and we've come out of it. We've come out of it. I mean, slavery was not a minor matter, nor was what took us a long time. The Jim Crow took us a very long time. But we're not out of it completely yet, I know. But we've come through difficult periods. And this may be a difficult period. I'm optimistic. I'm optimistic for the reasons that I've said.
You took the follow-up out of my mouth. What gives you optimism? Because of our history?
We have our history. We have our ability, and I think it's there, to get together and form a project, and we'll get it done. And COVID and the things I talked about were that. And we also have deep in people's minds, and I think they used to learn this at school, and I hope they learn it again. And I hope again and again they teach these kids what our government is like. 320 million people, every race, every religion, every point of view. And we can stick together, and we can, and we've done it, and we will do it. That's my own view. And what I want to tell the students is, do it. Do it. Sure, we've had bad periods. Of course we have. But we know how to listen to each other, and we know how to formulate groups. And we do have this document, and we know what Lincoln said, and Washington. Lincoln, you know what he said? I get it wrong all the time.
Which part?
The Gettysburg Address. They all should memorize that. 67 years ago.
Yes, you paid your children and grandchildren to memorize the first lines, right?
We've had, correct.
Yes. Why is it so important that everyone knows the lines of the Gettysburg Address?
You know why he says 67 years ago? It's not the Constitution he's referring to. Declaration of Independence. Created equal. That's what he wants there. Our fathers came across, our fathers created this nation, created in liberty, conceived in liberty, and dedicated to the proposition that all men are created equal. They meant women too. And we are now in the midst of a war to see whether that nation or any nation so conceived and so dedicated can long endure. You see what that comes down to in one word? Experiment. In which they knew those Lumiere in France and the Lumiere, the Enlightenment up in Scotland, the Scottish Enlightenment, the French Enlightenment, they all knew perfectly well that those intellectuals over there are thinking we have fine ideas, but the Americans will never be able to do it. And we show them, yes, we can.
You talk a lot about the experiment of democracy. Where do you think we are in the arc of that experiment?
The ups and downs. Some places they're ups, some places they're downs. Every day, of course, you want readers, you want viewers, and so maybe people like to look at pessimistic things, but they also like to look at optimistic things. And so you can find in those newspapers and on that television and so forth, every day you see something that says, yes, we will help with, over time, the problem of homelessness. We will, in fact, see that those kids in the 3rd grade or the 4th grade or the 10th grade or the 12th grade are going to understand how their government works.
Let me just ask you a couple of quick questions before I let you go. On the topic of trust in the court, as you know, over the past year, there have been numerous reports about expensive gifts, free trips, real estate deals that the justices didn't disclose. Do you see that as corrosive to the court's standing with the public? I
think it will. You'll get out eventually. I mean, I had in my office, of course, 7 volumes, I think. 7 volumes of a code of ethics that applies to all judges. And I'd read them when there was an ethical question. And if it's a tough question, I would call an ethics professor usually and say, what do you think? And there are rules, and this is pretty bureaucratic in what you report. And so you might have an accountant who goes and will do that, and sometimes somebody will make a mistake. All right. Of course, you have to be ethical. And the court now has, I think they sent letters or what something recently has happened with that. And of course, people have to have confidence that the judges are ethical.
Do you worry that some of these stories about a lack of transparency on gifts that have been received run the risk of making it look like the justices don't believe that a code of ethics applies to them?
Sure, there's a risk that people will believe that, but this is not so simple as you think. We have, say, 5 or 6 or 7,000 cases a year, and if you own a share of stock and you're not very careful in checking, and it happened to me, I mean, lo and behold, I sat on a case and my wife owned a share of stock in it. So what can you do? You say, I'm sorry, I didn't do it purposely, but that can happen. And also, you don't want to get into it's tough in the Supreme Court for this reason. In a lower court, if Joe Smith, the judge, doesn't sit, hey, somebody else can take his place. You can't do that on the Supreme Court. And you don't want manipulation through this of which judges are going to sit, because that can affect the result. So I'm saying it's complicated, difficult, mistakes sometimes are made. Sorry about that. Sorry about that. Always. Always. And go read those rules. And they are very, very complex. So it's not surprising. There we are. Would I prefer never to make a mistake? Of course. Of course. And do I think that the judges should behave ethically in respect to the way those rules are all written in those 7 volumes? Yes. Sometimes there is a special situation where you can't, etc. But by and large, they should, and I think they are followed.
You've expressed skepticism that cameras should be allowed in the court. Do you still feel that way, or do you think that allowing cameras in the court could actually add to a sense of transparency?
No, you see, I have opposite reactions. In Canada, they let them. I mean, lots of places they let them in, and there's been no harm. Criminal cases are tough because not necessarily our court, but you don't want the jury to be affected. But if people could see, if they could see, for example, when I thought this, I was discussing it. We were discussing with Tony Kennedy. The case about term limits for congressmen? Could the state impose term limits? You would have seen 9 people so, very tough case, really worried about it. And you saw some of the founders who thought the answer was yes, you could add requirements, and some of them thought no. And there were some cases that seemed one way and some the other. They would see people serious about their jobs, and that would be a plus. I think very definitely a plus. The risk is that I'm not saying it would, maybe it just wouldn't happen, but and in places it wouldn't. But one of my colleagues once said, "Oh, look at that picture of X," one of our other colleagues, in the paper. When the paper agrees with you, they run the nice picture of you. When they disagree, they run the bad picture of you. And there we are. And you can't do much about that. And once you get into it, you're never going to get out of it. And so there are arguments both ways. But I think we have been broadcasting more, and I don't think it's hurt. I don't think it's hurt.
No. On the topic of transparency, very quickly, and I know you have expressed that you have a very good relationship with Justice Thomas. Given his wife, Ginny Thomas's engagement and efforts in trying to overturn the 2020 election, do you think he should recuse himself from the immunity case?
To answer directly, I don't have enough information, but I'll tell you this. I do have a rather independent wife, and I do think it is important that spouses now, in today's world, make their own decisions. And there we are.
Finally.
I'm not saying she was right or wrong in that decision, but I do know that she is an independent person, and you have to hold these things in principle across the board. So it's their decision. As far as I know, I don't know the details of it.
Finally, you have written this book at a time when you have said we are at a tough moment in our democracy, but you still have optimism. What do you hope people will take from your book? What is your message to the country in this moment of this experiment in our democracy?
Well, first of all, understand the institutions, because they're your institutions. They're not mine. We built this courthouse in Boston. We told the architect we want the people of Boston to believe when they see it, it's theirs. It doesn't belong to the judges or even the lawyers. Okay? So, understand. And second, I think that I would like people in reading this to see that the judge's job is a very serious job, and it's one where it is important to take into account what the legislature wants to do, to take into account the values that underlie this document, to take into account the consequences of what a decision will be one way or the other. Values, consequences, purposes, all have a role. And a good judge, and none of us knows if that's how later generations will or will not regard him or herself. But a good judge takes this seriously, tries to do it as best he can, and draws upon the experience that he's had. And that's a better way of going about reaching judicial decisions than it is just to read the words. And so what I fear most is probably that if we just read the words, that moves law slightly. I don't want it to, but moves law slightly in a direction becomes harder for the law itself to achieve its basic objective, which is to help Americans or countries that follow this kind of a document, that it helps them, now 320 million, live together better, peacefully, and we hope productively. And if that diminishes, then people could lose some of the confidence they have in the system of law, which is a system, not the only system, not the only system, not our only weapon, but an important weapon in holding us together in a nation that has the values that are right here and in which people can work together. That's my most important belief about this United States of America. And of course, as I've said 14 times, I think we can.
Thank you, Justice Breyer. I really appreciate it.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.